Good morning. I keep hearing a lot of talk about unlawful arrests. Every time any auditor is arrested, the other auditors and the commenters will proudly proclaim that the arrest is unlawful. It was an unlawful arrest. Well, there's really only one way of knowing whether an arrest was unlawful, and that is if a court determines that the arrest was made without probable cause. But what does that mean? What does it mean if an arrest is unlawful? Well, it doesn't really mean much. If an arrest is unlawful, then any subsequent evidence gained pursuant to that arrest may be suppressed and may not be usable against the defendant. But beyond that, it doesn't really mean a whole lot. Obviously, if the probable cause didn't exist, and at the probable cause hearing the judge says that there's no probable cause, there's insufficient probable causes, the way the judge will term it, then the case will probably be dismissed, although maybe subsequent investigation will continue and the case may be reopened. But anyway, I'm digressing. The instant thought by auditors and commenters is that, well, the arrest is unlawful and therefore sue, and gonna win. And there are some significant hurdles in place. First of all, I want to point out the relevant standard of probable cause is different than what some people take as evidence of a lack of probable cause. If a person goes to trial and is found not guilty, that does not mean that there was not probable cause. Probable cause and reasonable doubt are two different standards of proof. Beyond a reasonable doubt requires that you convince a jury or the judge in a bench trial that this happened beyond a reasonable doubt. There's no reason to think that it did not happen this way. There's no reasonable reason to think that it didn't happen the way that the prosecution laid out. It's vastly different than probable cause, where all you have to have is that a crime was probably committed and that the suspect was probably the person who committed the crime. It's very, very low bar. It's higher than reasonable suspicion, but it is miles below reasonable doubt. Likewise, just because a district attorney dismisses a case or requests dismissal or drops charges, again, that has no real bearing on probable cause. There are countless reasons why a district attorney might drop a case, might request to have a case dismissed or drop charges. And one of the reasons that I have seen more times than I thought before I became an attorney, I've seen this now more times than I thought I ever would, was that district attorneys have huge caseloads. And a lot of times they'll drop small potatoes kind of crimes, like a simple battery where nobody was hurt. It's just not worth prosecuting. It's just not worth going to court on. And if they get any pushback at all, if the person isn't willing to take a deal, they may drop the charges. Not because they can't prove it, not because the simple battery didn't take place, but because it's just not worth their time and effort to go to trial on it. Similarly, just because a judge at a probable cause hearing says that there's no probable cause, or a jury at a grand jury indictment says there is no probable cause, does not mean that there was not probable cause at the time the officer made the arrest. And let me give you an example. This is not from California. This is from a different circuit. I think this is from the 8th Circuit. So it's a different law, different criminal domestic violence law. But the there was a 911 call from an apartment that hung up on the 911 operator. Officers were dispatched. They hear arguing from inside the apartment. They enter the apartment and they see the suspect standing reasonably close to the victim, like 3 or so feet away from the victim, the alleged victim. The alleged suspect, or the suspect and the alleged victim, there you go. And he's yelling at her. And she's down on the floor crying. And so, they arrest the suspect for domestic violence. Now, did they have probable cause? And yeah, they had probable cause. A crime was probably committed. And the guy standing over the woman yelling at her probably committed it. That's a pretty simple one. Well, it turns out that she was not in imminent fear of bodily harm from him, which is a requirement in that particular state for a criminal domestic violence charge. And so he was found not guilty. And then he, of course, sued, and the court said no, they had probable cause. And in the standard, you have to look at it what the cop knew at the time he was making the arrest, just like reasonable suspicion. At the time the officers were making the arrest, they had the hang up on 911. They had a 911 call and then a hang up. They had the argument. They could hear the argument from outside. When they entered, they saw her on the ground crying. They saw him standing over her, berating her and yelling at her. They had enough that they could say a crime was probably committed and that the suspect probably committed the crime. And that they learned afterwards, after they made the arrest, that she didn't have the requisite fear, apprehension of imminent physical harm from him. That doesn't change the fact that they had enough at the time of the arrest. The subsequent exculpatory information was not relevant to their decision-making process at time of arrest. And so, when you look at two examples, let's take two cases from Leon Valley. You have the arrest of Pink Camera Magic, Amanda Burquist, something like that. And you have the arrest of the Gadfly, extra good citizen, whose name I forget at this point. Those are two different arrests, and the police reacted to them two totally different ways. And there is a reason for it. With the arrest of Pink Camera Magic, as soon as the I don't know if it was a district attorney or if it was Salvaggio or a lieutenant or somebody up above those two idiots, as soon as they found out what happened, they immediately dropped the charges. Because that particular arrest was unlawful to the point and lacking probable cause to the point where it would expose them to liability. Which is entirely because at the time the officers made the arrest, there is nothing that they could articulate that would suggest that there was any that it was probable a crime was committed. There was no crime being committed. She's standing out on the street with a sign that said "fuck Joe and the Leon Valley Police" or something along those lines. There's no crime being committed. So they completely lacked probable cause. And so they are exposed to some really, the liability is clear, the damage is probably not so much. But then if you look at the Gadfly's arrest, where he bumped into the back of the officer, what did the officer know at the time he made the arrest? The officer doesn't have to stop and review the footage before he makes the arrest. And even after viewing the footage, they might think that they could push this one through or get the Gadfly to pay the ticket or what have you. But at the time the officer made the arrest, he had his back to the Gadfly. He didn't see what the Gadfly was doing. The officer knew that the Gadfly touched him. And that was enough. It was an offensive touching. He knew he was offended by it. With what he knew, he didn't have to know the intent in order to make the arrest, in order to have probable cause at that time to make the arrest. And so the gadfly situation, it is going to be less likely that the arrest was unlawful than the pink camera magic situation, which is incredibly, almost guaranteed to be found that arrest was lacking probable cause. So then once you have an unlawful arrest, like in pink camera magic situation, where it is on its face an unlawful arrest, then you have the problem of qualified immunity. And qualified immunity comes into play in those little gray areas. Now, there's a split in the courts on how you figure out whether or not the officer is entitled to qualified immunity. It's a two-prong test, and the two prongs are slightly different between California and Texas. California, it is did the officer violate somebody's constitutional rights? Somebody's clearly identified in a particularized enough way, clearly identified, so that a reasonable officer, a reasonably prudent officer, in the same or similar circumstances with the same or similar information, would have thought that there was probable cause. Those are the two prongs. So there has to be that reasonably particularized violation of a clearly established right. Excuse me, there has to be a violation of a constitutional right that is clearly established in a particularized enough way that the officer should know from the facts that it's being violated. And then the second prong is, to slightly differentiate between the two, is that a reasonably prudent officer in the same or similar circumstances with the same or similar facts would have believed that there was probable cause. In Texas, it's a little bit different. I think Texas follows the majority rule. It's called arguable probable cause. And that's where it's the same thing as far as the constitutional violation is concerned, but the second part is where reasonably prudent officers may have disagreed. They should have known. That's a better way of phrasing it, I guess. It's where reasonably prudent officers should have known, whether they should have known that it was a violation. There can be some disagreement between reasonably prudent officers. It's a bit of a weird standard that I don't entirely understand, but that's Texas for you. So that said, you have to overcome that as well. Does the officer know enough in order to get probable cause, or excuse me, in order to get the qualified immunity, which is basically going to bar you from recovery from the officer? Would a different officer, would a reasonable officer in the same or similar circumstances have also thought that there was probable cause? So that's a further bar. So I know that's probably more than what you were looking for. That's like 13, almost 14 minutes of me babbling now. But that is unlawful arrest, kind of in a nutshell, from a first-year family law attorney's perspective. So thanks for watching, and have a great day.